Good afternoon, everyone, and welcome back after a little longer break in our talk series. So today is the fifth talk of our only one theme awareness session, and this talk is going to be around only designs. I'm very happy to welcome Mr. Ravi Bhola. Ravi is chair of the patents practice at K&S Partners. Ravi has handled filing and prosecution of several thousands of patent applications for clients in diverse areas of technology, such as biotechnology, bioinformatics, software, nanotechnology, pharmaceuticals, electronics, communication, and mechanical. In addition to this experience in the domain of patents, Ravi also has vast experience and expertise in the handling of design applications and issues related thereto. So that being today's topic of interest, which is only designs. During his practice, Ravi regularly renders opinions on issues related to designs and patents, ranging from licensing, assignment, pre- and post-grant oppositions, freedom to operate, technology landscaping, due diligence, IP portfolio building strategy, patent pooling, and assists clients in negotiations and enforcement of patent rights. He represents several multinational and domestic corporations on a variety of issues and works very closely with several startups and spin-offs. Ravi regularly conducts workshops on patents and designs and also sessions on invention capturing for its clients. Ravi is a member of the IPR Committee of Federation of Indian Chambers of Commerce and Industry and Confederation of Indian Industry, the leading industry bodies in India. He also serves as a member of CII's national committees on biotechnology and pharmaceuticals in 2019-20. In addition, he is a member of the Executive Council of Association of Biotechnology-Led Enterprises, ABLE, and also a member of the Institutional Committee for Stem Cell Research at the Institute of Stem Cell Science and Regenerative Medicine. So with this brief introduction, welcome Ravi to the session and over to you.
Thank you so much, Dr. Mukta, and good evening to all. A big thank you to Venture Center for having me for this session around designs. What I'll try to do is that I will run a short slide deck to talk to you about designs and the registration and enforcement around designs in India. And then, of course, we will try to keep it interactive. So please feel free to type in your questions in the chat section. I'll be happy to take those questions during the course of this session. And at the end also, I'll make sure that we have enough time to take up some follow-up questions that you may have at the back end of the session. So with this, I'll quickly share my screen. Okay. I believe you can see my screen, right?
Yes, your screen is visible.
Excellent. Let me see if I can make it shorter. Okay. All right. So, when we talk about design, it's obviously a component of intellectual property. And when we look at any innovation, it will have, a same article can have various kinds of protections, like here in this image, you see this robot can get protection for patents for functionality, copyright maybe for the source code, or maybe the way the robot expresses itself, branding in terms of trademark. And as I understand, you all had sessions around only patents, only trademarks, and only copyright. Now, design is a protection, a kind of intellectual property protection, which is exclusively for the look and feel of the article. What you see with your naked eyes, how the article or device or any material appears to your eyes, totally independent of its functionality. Totally independent of its functionality. And the protection is for that aesthetic look of that article, the design part, not the engineering design part, the design part in terms of look and feel of the article. Right. So therefore, it's different from the other forms of intellectual property that you would have, heard about or read about. Now, when you're seeking design registration, so one, of course, your idea is that if you have an innovation, you want to have multi-layered protection, right? I mean, you can have a patent protection for an article, and you can also have a supplementary protection by way of designs. Or you could have a scenario where certain things may only qualify for a design registration. Now, when you're seeking a design registration, you're essentially, what are you looking at in terms of article? You're looking at the shape of the article in question, the whole configuration, how the whole article is designed, any ornamental element that the article may have, or the patterns or the lines and the color combination that you may have used on that article to make that article look attractive, appealing to the eye. As I mentioned earlier, it is solely directed towards the aesthetic look or attractiveness or the visual aspect of the article, nothing to do with the functionality of the article. Okay. Now, when you look at the design protection in India, we have Designs Act, just like you have Patents Act and the Trademarks Act. You have the Design Act, which essentially regulates what kind of articles can be registered as design. And similarly, all the countries that provide for intellectual property protection in their respective jurisdictions, they would have Design Act or design laws to provide for that kind of a monopoly. So what you're doing is when you're filing an application for design, let's say with the Indian Design Office, it is examined by the Design Office. And then once it is registered, and we'll talk about the process in detail in a while, but then you get a monopoly over that design on that article in India for a particular period of time. So for designs in India, it is 10 years, which can be further extended by another 5 years in case you need extended monopoly for those 5 years. Now, so when you're filing an application, you are looking at how you position your article, be it a 2-dimensional or 3-dimensional article. You focus on different views and different perspective views or front view, rear views to clearly showcase how the article looks like. Section 2D of the Design Act talk about, that what is a design, something which is applied onto an article. So the article takes the shape of the design, and your monopoly is for that design on that article. Okay, and it could be prepared or manufactured by way of an industrial process, which could be manual or mechanical or chemical. And you can, of course, you can have a single article which may have different components, and if different components have their own individuality in terms of aesthetics and all, then one composite device may actually qualify for separate design registrations. So a lot depends upon whether individual components of an article on their own stand alone. Do they have that kind of a visual appeal to qualify, which means that they also separately sold and bought as a commodity, and that may also play a role in terms of registration, those design registration for those components. So here is a kind of a illustrative list or images of various kind of articles which can qualify for design registration. Now, you may have a question that, a fan is there or a chair is there. They have functionality. So why would they qualify under design registration? Now, the fact remains that while these articles, they all will have some functionality or the other, but the monopoly sought and the monopoly provided is for only the look and feel of the article in question. So for example, this chair, there could be a lot of science involved in terms of the seating so that it's comfortable for the occupant, but that will be more around the functionality part of it. But design registration would be focused only on the way the chair looks like, independent of whether the occupant of that chair feels comfortable or uncomfortable. So the monopoly is for the look and feel. And often we buy products. When we look at the products which are showcased in the marketplace, our first impression about the product is based on what we see from a distance, right? And that's where the design registration as an element becomes important. Same thing holds good for your automobiles here, for example. They all have functionality, but then your first impression of an article in terms of just the aesthetic look is what design registration is all about. Now, when you are seeking design registration, as I briefly mentioned earlier, there are certain criteria. Not everything for which you will file an application for design with the design office, will get registered. So there are certain criteria involved, basis which every design application which is filed with the design office is reviewed, and you can have situation where the design examiner will get back to you with objections. You have to overcome those objections, and then only your application can mature into a registration for design. Now, so when an examiner is looking at your application, what he or she is looking for, he or she wants to make sure that your design for the article for which you're seeking registration is novel or is original. When you say novelty, it means that nobody in the world should have, had, developed or seen that design. It should not be in public domain as a design. So that's a novelty requirement. Or the design should be original. Now, original is different from novel. Novelty is that design should not be known anywhere in the world. Originality is even if the design is known, but it is applied onto an article in that form for the very first time. And I'll give you an example. Let's see if I have the image here to give you an understanding of this. So for example, here, if you see the image is that of a bear. Now, we all know that this is the design of a bear, right? But the point is that the design has been applied onto a bear shape, let's say a file rack, okay, or a bookshelf, for example. Now, so the design is not novel, but the design is original because it has been applied onto this kind of a design to have an article, which is essentially a bookshelf in the design of a bear. So this is how originality works out. So you will see often cases where design applications are filed where the design might not be novel at all in several cases, but will be original in that sense. So this is how it is understood. Now here, is a kind of a flow chart to give you an understanding of how a design registration process looks like. So typically in India, today, things are so streamlined that you can on an average get a design registration in something like, 4 to 6 months. Almost entire process from filing till registration and maintenance is now digitalized. In a way, helped precipitate some of these changes of digitalization at the design office. But generally, in terms of timelines, design office in last 7-8 years have been particularly good. So typically, I would say in 6 to 8 months next, you will have the registration in India for your design application. So the process is that, look, unlike patents, where the quantum of filing of patents is considerable and process is more complex, or in trademarks where trademark registry receives something like 3, 4, 5 lakh applications every year. Design application examination process is much simpler, much shorter, and also the quantum of filings are not that high. And therefore, right now the system in India is that while you can file the design application with any of the 4 patent trademark design offices, your application will be examined only by one office, which is Kolkata office, because all they need is a small team of 2-3 examiners and controllers to do it. because the quantum is not huge. So while you're sitting in Bangalore, today, for example, I can file an application in Chennai office, but it will be forwarded to Kolkata for examination. And then I'll get examination report or hearing, kind of notice from design office in Kolkata. It's working quite well. So typically when you file an application, your application will be taken up by the examiner, in a sequential order in which you had filed an application. And then you will get first examination report. There could be some instances where you may not even get first examination report, and based on the way you had filed an application which was in good shape, the design office may directly grant you the registration. It can happen. But let's say your application is filed, design examiner looks at the application, finds some deficiencies, and will issue a first examination report. It will have a bunch of objections, say, okay, this representation sheet or this view of the article is not clear, or you've not identified this or that, and things like that, or here is a prior art in view of which your design is not novel or not original, and all kind of objections you can receive. Now, once you have those objections received, you have to file a response to this examination report. Okay. Now, typically you get about 6 months from the time you get an examination report. You have 6 months to file a response to the examination report to put the case in order. And you can, if you require, you can get an additional 3 months, and then you get 3 plus 6 months. But generally, most of these objections are pretty basic, and then you can very quickly file a response. And then if all goes well, like here you see in the flow chart here, you filed a response to the examination report and you've complied with all the requirements, your design is registered, and then it is published so that the public can get to know that this particular article is protected by way of design registration. Okay, now that can happen. Other scenario is you file the response, objections are not fully complied with, and you get a, let's say, a hearing notice. Okay, objections not complied with, you get a hearing notice. In this hearing notice, which could be done digitally, remotely, or in some cases, if you believe stakes are high, you can go in person also, make a request. And then during the hearing notice, you try to convince the controller, put forth fresh arguments, and then your registration takes place. Okay. If God forbid, and it happens very, very, very rarely, maybe one out of 500 cases, maybe, or 1 out of 1,000 cases, where even after hearing, rejections are not taken care of, and then your application is rejected by the design office. You have an option to file an appeal in the High Court to challenge the order of the controller of designs, and then your appeal will be heard by the High Court. So this is how typically the process runs. Our own experience, as I mentioned earlier, is that typically from the time you file an application till the grant and publication, it is about 6 to 8 months journey. Pretty straightforward, streamlined journey. Okay. And once you have a registration done, you're advised to, on your article, you mention that it is registered, and if required, you can also mention the registration number that you get from the design office. So typically this is how it works. Now, in terms of filing cost and all, it varies. Typically for an applicant, which is let's say a large size or a mid-size company, your government fee is 4,000. As I mentioned, protection term is 10 years from the date of filing. And then if required, you can seek extension for 5 years. And that extension request has to be made before the expiry of 10 years, 10-year monopoly. All right. So this is how generally it works. Now, once, let's say, you get the protection in India, it means that your monopoly is only in India. In other words, others can see your design because it is published in the scientific, in the design journal. People outside India can use your design. You have no control over them because your monopoly is only in India. Now, if you have business interest in other countries, then you have an option to file design application in other countries based on your interest, business interest, and other strategic reasons. And somewhat a similar process will be run in those countries as well. And then, of course, the priority date becomes critical. So let's say you started off by filing first in India. So that becomes your priority date. And the idea is that you file in other countries which are of interest to you within 6 months from the first filing that you had in your first country for that application. Now, when you file an application, you are required to follow a classification process to categorize your product into one of the prescribed categories, what we call as a Locarno classification. And Locarno classification is an internationally recognized design classification system followed in almost all the countries in the world. And you identify in which class your article belongs. So for example, for utensils, for example, they may have a class. And within the utensil category, there could be some subcategory. So you identify a subclass within the utensils as a class, for example. And then you say, this is my class and this is my subclass, and you file an application. So therefore, your monopoly is essentially around that class and that subclass. So you have to be careful in which all classes your article will qualify. So be mindful of that part. And then, of course, once your monopoly expires, which is, let's say, 10 years plus you took another 5 years, 15 years beyond that, then you don't really enjoy the monopoly thereafter, which means the design falls into public domain, which means people can then start using it without your permission. But anytime during the time when you have the monopoly, the third party who's interested to use your design is required to take your permission, take license, and then do it in those countries where you have a design registration. All right. Now, this slide here gives you kind of a quick overview of the filing fee in India. For natural persons, is 1,000. For MSMEs, it is 2,000. And for other companies, which are generally classified as large entity, it is 4,000. And this is how generally I told you how the examination process follows. Hearing, which happens in very rare cases, otherwise just examination report and you get the grant or registration. And then there's a publication after the registration. Okay. I'm just wondering, maybe I can pause here for a moment and see if there are any questions. I don't see any question in the chat section. If you have any, please feel free to type in and I'll try to respond. I'll move ahead. Now, we talked about registration in India. Now, let's say if you want to file application for registration outside India. Now, let's say, like in patents you saw earlier, that you can file a single application called European patent application to cover entire Europe. Similarly, you have OHIM as a mechanism through which you can file a single design application to cover entire Europe. Now, India is not a member of the Hague Agreement or Hague Union, but currently there are 66 contracting states. What they do is by filing a single application, you are able to actually get then registration in multiple countries. Because India is not a member, therefore, if we have to seek monopoly or design registration in any of those Hague member countries, for example, all the big markets, all the major developed IP markets and developed countries are member of Hague Union. So, for example, US, Canada, UK, many countries in Europe, South Korea, Japan, China. So all these countries are a member of the Hague Union. And of course, there have been discussions about India getting into this, because once India gets into it, becomes very easy for us to then have a single application to cover multiple countries. But member states in The Hague have that option to do it. So today, if we have to do it, we have to go to each of the individual countries and seek registration by way of design in those countries. Now, one important thing, since we are discussing here about protection in India vis-a-vis protection in other countries. So I have seen in India, in a single design application, you are not allowed to cover the variants of that design. So for example, if you have an article, I'm just thinking what example I should give. Let's say you have a cutout cap, you have those, let's say if I can take this article here. So you have this, let's say a cutout cap, through which you can harness the wires from the table. So you have a table with a cutout cap, and you can, turn it around and you can harness the wires, and then you can plug them into your laptop and other devices. So if this is, let's say, the design which is I'm seeking monopoly for in India, I will be able to give only this as one design in the single design application. But if I am in Europe, I may have an option that in the single design application, I can not only seek protection for this design, but also for its slight variants. For example, if the edge here is very sharp, but if I make this edge slightly softer and milder and not so sharp, I make it slightly blunt here at all the 4 places, for example. But in the same application, I'll be able to cover 2 variants as an example, or I can probably even try 3. So in single application, in some jurisdictions, some degree of variation is allowed, not in India. In India, single application will entertain only one variant or one design. Other variations are not covered in the same. You have to file a separate design application for each variant. So therefore, it becomes a bit of a limitation in India in that sense. Having said that, if you look at jurisprudence around this, while it is the best that if you believe that you're, any prospective infringer or a prospective licensee may have some other variations in mind beyond this, it's advisable to file separate design applications for that in India.
Ravi, yeah.
Is it okay now? Was I muted in the?
Yeah, you went on mute.
So, all right. So, for how long I was muted?
No, just a few seconds.
Okay, all right. So, all right. So, as I was explaining that those variants can be protected in, let's say, Europe for sure, and maybe some other countries as well. In India, you don't have that kind of flexibility available. Now, interesting thing, what we have seen in terms of enforcement in such situations in India. So, fortunately, in courts, the kind of jurisprudence we have seen is that if I have a design registration and I'm enforcing my right in the court in India, there is decent amount of jurisprudence available through past judgments and orders that if an infringer has made an insignificant change vis-a-vis my registered design, just to bypass my registration and bypass that infringement action, the courts have taken a very kind of a broad view on the scope of protection to say that because what infringer made was only an insignificant variation of what was registered by the plaintiff, and therefore in many such cases the defendants have been injuncted or adverse orders have been passed against the infringers or defendants in such cases. So fortunately, while in terms of registration, you can't have variations covered in the same single application, but often in the enforcement time, you are able to still get coverage for a little bit of a insignificant variation that may have taken or may have been brought in by the infringer. Now, I'm not suggesting that you rely upon this and don't seek registration for variations. The ideal situation is you have variations also covered by separate registration so that your case is strong in the court of law. But just to let you know that courts have been also considerate to understand that if an infringer with ill intention is only making some insignificant minor changes here and there, but largely the article still looks and feels the same, then they said the infringement is indeed established.
There are a few questions right now.
Sure.
Can we take them right away?
Yes, please. Yeah.
Yeah. So, Sudhar Godi, do you want to unmute yourself and ask your question?
Actually, regarding this variance, if I'm filing two variants in examining, will the controller allow minor variations like even for same applicant?
Yeah, if the same applicant, the idea should be to file those applications simultaneously, so that one application doesn't become tomorrow a prior art for the other application.
Okay.
So if you are looking at, let's say, one article but 2-3 variants of that, it's advisable to file those applications simultaneously, so that they are parallelly examined. And as I mean, we do it quite a bit, and it's sometimes examiner, because often because a small team of examiners, it will go to same 1 or 2 examiners.
Yeah.
And if they're filed at the same time, they look at all those 2-3 cases and say, hey, they look very similar and all. But you have to obviously then you have to argue out the case to say that the difference you see, let's say the example which I gave you here. So you have to then focus on the difference and say my novelty resides in this variation vis-a-vis the earlier application that I have filed. So it's doable from same applicant. Variations are all absolutely fine. Yeah.
Okay. So I have one more question.
Sure.
So I did a design where the object was a box with the opening, but the idea was to have the cover camouflaged. So it was like the cover will be visible, the outline of the cover will be visible only on close inspection. So I filed with the overall appearance of the box, and the cover alone I zoomed out, and because only on close inspections are visible, so I kind of zoomed out that part alone and submitted. Is that okay? Like
so I'm not sure whether I've understood the cover part story clearly. But I'll tell you, based on our experience with such cases where the article has a mechanism to open and close, for example, an Elmira, for example, right? Yeah. So you have closed shutters, then you have one image, and then you open the door or the shutters, and then you have the interior view of the Elmira also visible. Now design office is generally of the view that you should file 2 separate applications. One for the design of that, let's say, Elmira or your box, which is in closed form, and the other one when it is in the open state. We have argued out against this quite a bit. I mean, we feel that this requirement should not be there. But often design examiners rely upon the Design Act, which says that when you sell a commodity or when you showcase the commodity, if it is, let's say, is visible to the customer, let's say it's either closed or it's open, it can't be in both the states at the same time. And that's the line of argument. I mean, we're not very convinced with that line of argument, but sometimes we have to give in because you don't want the case to get dragged for too long. But that's how it is generally seen.
So but my point was, when the a feature is not clearly visible in the overall picture. Can we zoom in and show that picture?
Okay. So yeah, so in that context, it is fine to give a kind of a zoomed in view, but just clarify that in your representation sheet that this is a zoomed in view of that cover. So I believe generally they should be okay with that. Very rarely they ask for article to be shown in person, very rarely. And if it, God forbid, if it comes to that, you can always show the article in real to them so that they are convinced. Yeah.
Thank you.
Yeah.
So there's a related question from Gandhali who wanted to know that will the previously published design from the same owner cause problem for the variants publication?
Sorry, let me just read this here. This is.
So this is the question from Gandhali.
Is it
the last one first?
The last. This is the one. Will the previously published design from the same owner causes a problem for variants publication? So we are saying that the owner had already filed and previously published design, which is a journal publication, you mean to say, cause a problem for the variants. So, okay. So as I understand, you're saying that the creator of that design of an article had already published it, let's say, in newspaper or in marketing material or something like that, and then has subsequently filed an application for the variant, and whether that variant will face problem or not. Is my understanding correct?
Gandhali, you can unmute yourself. Gandhali, are you able to unmute? So I think she's asking that one variation has been published and
Subsequent one.
A subsequent one.
Hello.
Yeah.
Hi, sir. So I was asking, like, if I have designed, if one design patent is, design is published already,
Sure.
and then later on, if we have some changes
Variants.
which are variants. So will those earlier ones will just like in case of patents, it is already published data and you cannot then So, but in the meanwhile, I think you answered that question that it is expected that simultaneously this should be done if the significant variation is not there.
Yeah, so that is one, of course, the ideal situation where you can do it simultaneously. But let's say for some reason, if you're not able to do it simultaneously and one gets filed first and registered and published and the second one has to be now filed, of course, you should make an attempt to get registration for it. There is a possibility examiner will identify your earlier registered design and say, in view of this design, your fresh application is not novel or not original and hence not registrable. Now, in those cases, your argument could be to focus on that differentiated part, and you have an option in the design prosecution to just to narrow down your protection only to the differentiated feature by putting a mark and an arrow and say, this is the novelty part of my article. So if you are willing to, let's say, narrow it to that small variation that you brought in that variant, in the representation sheets of your subsequent application, then the examiner will most likely allow the case for that variant.
Yes. Thank you. So there are two more questions. One is from Shruti. A common design made with a newly engineered material, is that a protectable product? But does she refer to the patent part of it?
Yeah. So my common design make with a newly engineered material. Yeah. So I think the nature of material and some dimensions of the articles are not that relevant from design perspective. This would be more maybe relevant from patent perspective. So in design, using a different material would not really have a bearing in terms of design registration, unless of course you say the material you used brought in an entirely new look and feel to the article. And I mean, we to envisage those scenarios. But if it's just a change in the material, then it is not really a matter for subject matter for design, but could be a subject matter for patent protection.
Yeah, thank you. So this last one from Hardeep. Does design only refer to parts visible on the surface of the product, or can it be referred to internal non-functional components also?
Yeah, so this, Hardeep, is something I think I was in a way indirectly answered when Gandhali asked that question. It is, I think maybe in the subsequent slides, I also have one or two examples where, for example, if you have a wallet and you're seeking design registration for a wallet, so the design office would say, hey, all I can see right now is the external appearance of the wallet. But when you open the wallet, it has pockets and all that design and things like that. That is not visible when the wallet is generally traded or bought or sold in the market. And therefore, in one application, the design office will be comfortable giving you monopoly for the closed form of the wallet in that case. And similarly, if you're looking for another protection for the inside view of the article, then the advice is to seek a separate registration with the open view of the wallet. But in the same application, design office will not entertain the two. Now, of course, even when you're giving the inside view in a second application, even if those pockets and everything have functionality, but obviously you will not focus on any of the functionality or non-functionality element. You just focus on how they look like only from aesthetic point of view and seek registration for it.
Okay, thank you. We can proceed.
All right, thank you. So here we were talking about protection in other countries that might be of interest to you. Sorry, this text here is probably not very sharp, but this is just to give you trends around filing of design applications in India. And just like we've seen in other forms of IP, even in patent designs, we see a good increase in filing, examination, registration, and disposal of applications. So if you see, this part is for the filing of the design applications. And for these years, this is the data we have. And if you see, it's been increasing from something like 11,000 to something like 14,000 plus, over the last 5 years or so. Similarly, for examination also, number of applications examined every year have also gone up from something like 7,000 here to as many as 13,500 or so in a year. And then overall registrations also have gone up, as I can see here. And then overall disposal, which means grants and rejections or withdrawals and closures and things like that put together. So you see, I mean, generally, I think there's hardly any backlog, so to say, in the design office for design matters. It's pretty quick. And trust me, I mean, we do have applications in other jurisdictions also, like Europe and USA and things like that. They all take about a year or more than a year for registration process, and obviously are far more expensive. In India, it's faster and definitely much cheaper. So overall, I think the government has put in quite a bit of an effort to streamline the entire filing, prosecution, and registration process. Okay. Now, just a few more slides here. I think this is more around when you are doing your overall filing of the design application. Like here, it talks about seek registration of obvious variations so that you can cover for what an infringer might do. Individual registrations of articles which can be made and sold separately. You can have situation like maybe I don't know, maybe a cricket kit, right? I mean, you may have a kit, but then different components are also independently sold and bought. So all that. and see wherever, a design article may also qualify for patents and other forms of protection. So be mindful of that you have a multi-layered protection. We have this very famous case, which ran for multiple years in the design side, this Apple versus Samsung case on mobile display. Both the companies, Apple and Samsung file tons of patents, and we always felt patent would be the big battleground for these big companies in the telecom space. But they ended up having this massive litigation on couple of simple design registrations for the mobile handset. The registration would have costed them less than $1,000, but then it became such a powerful right. So sometimes we underestimate the value of design registration, and sometimes as a strategy for some of my very aggressive clients who really believe, and in the products where the cycle is very short, 2 years, 3 years, and if patent is going to take, even as a startup, is going to take me 1 year, but I'm from a large company, it may take me 3 years to get a patent in India. But I will quickly file patent and design applications simultaneously. I'll get my design registration in my pocket in 6 months. And then if I know that it's a highly competitive field and my competitor will try to replicate my product, the moment I have design registration, I can go after my competitor by suing him for any act of infringement. Because you cannot go after your competitors for infringement unless you have a right in your pocket, right? Unless you have a registered design or unless you have a registered patent, you can't sue anyone, right? Because you yourself haven't got the monopoly yet. So sometimes in certain industries, design actually could be a far more powerful tool in a competitive landscape as compared to patent. So it depends upon scenarios. Now, typically in a design application, you will be asked to submit the representation sheets in terms of how the article looks like, the perspective view, front view, rear view, all these side views and bottom and top views. So all these views have to be provided clearly, and so that in the examiner can clearly see and understand what your design registration is about. And this is the rear side of that sheet when you do the design application filings, or in the digital, of course, it works differently. So here you bring in the novelty statement where you can say probably for the entire article, or in some cases, if the novelty resides on a particular part of the entire article, you can focus on that article, that part of the article, to say this is the novel feature of my design. And then, of course, you have a disclaimer in terms of any text or letters or numbers or dimensions, so all that. So typically, this is how representation. And this is where I was referring about the novelty statement. So in some cases, like the one on the right-hand side, this whole article, let's say as a centrifuge tube or something, is already known, but the difference is only in this part. So you can focus on this and say in your novelty statement that this is the novel part of your test tube and not necessarily the entire device. So this is how you can differentiate your product and establish novelty vis-a-vis the prior arts that the examiner may pull out and say, hey, this looks like every other test tube. So this is how typically it works. So this, I think, is a reiteration of what I had already mentioned. We talked about the functionality part and things like that. So you will have situations where your article will have obviously functionality. We saw the chair example, we saw the example of bike and automobiles and things like that. So you'll obviously have those cases, but always make sure never talk about functionality in your design application. The moment you talk about functionality, your application will go for a toss. Just focus on the look and feel of the whole thing. Now here is the last point here. You see what we briefly discussed earlier in terms of inside arrangements of a product. For example, you have a a box or a money purse or things like that. So registrability becomes a problem, and that's where the idea is to file two separate applications, one when it's all closed, other one when it's open, so that you are able to, push for registration. You may not have a consistent outcome at the design office, but the idea is obviously always to push the envelope around that. Now, other things where you also have to be mindful, which will not qualify for design registration, is anything which is obscene or scandalous will not qualify for registration under Designs Act. Similarly, certain features like if this key, if you see, if you focus on this part, which can be called as purely functional, right? This corrugation is what leads to the key to function and open the lock, right? So if you focus on this part of the key, you will have a problem to get registration, because they will say it is exclusively meant for functionality. So you have to be realistic in terms of what you can get or what you can't get. And of course, if let's say you focus on the other part of the key and not on the corrugation part of the key, then you have a case. So be mindful of certain kind of articles where their very existence is directly and irretrievably linked to the functionality and nothing else. So anything which is only and only functional, you will have difficulty getting registration. Anything which is only aesthetic, yes. Anything which is functional but also aesthetic, yes. Because here you will focus only on the aesthetics part of the design and not on the functional part of it. Now, one quick thing, I think we have about another 5-7 minutes left. So quickly on to one or two elements. Graphical user interface. Now, this is one hotly debated issue in the design office. Many countries in the world have allowed graphical user interface, GUI, to be registered. Some countries still have kind of a slightly divergent view. In India, interestingly, till 2010, we had a few cases of Microsoft registered for GUI, but somehow after 2010, we started seeing rejections in the design applications for GUI, and that trend has not changed till now. It's been 12 years. Now, even though in India now we have adopted the Carnot classification, which I talked about, is a globally followed classification for design registration. And Locarno classification does provide for GUI registration in terms of categorization of articles for registration. But in India, the design office is of the view that the way section 2D of the Design Act is worded, their argument is that GUIs are visible only when the mobile is in, or mobile or any device for that matter, is in power on state. So the GUI is not visible all the time on the article. So that's one problem they claim is there with GUIs. It's only available in power on state. Second, they say that the way language of section 2D is, the design for which you're seeking protection, the design takes the shape of the article. The design takes the shape of the article. So for example, here, if the design is, protection is for this paperweight, the design of the paperweight is the paperweight itself, right? But in GUI, it doesn't happen. GUI appears on the screen, but the shape of the article is that of a mobile or any other screen or a computer or a laptop. So GUIs, the mobile is not taking the shape of the GUI. So GUI is visible onto the device. And therefore, they say, as per the language of the designs in the section 2, there's a limitation, and therefore GUIs do not qualify. The discussion is on, things may change. I think things should change in this regard, but right now we have had tons of cases of GUI being rejected by the design office. So On the enforcement side, on the design side, you do not have a criminal remedy, which means that an infringer cannot be sent behind bars. It's a civil remedy which is available, which means that you can seek injunction if you see somebody is infringing your rights. You can file a case of infringement, and then the judge is convinced with your evidence. You'll be able to enjoy the injunction against the infringer, and also you can seek damages. The law, interestingly, provides for prescribed upper limits for damages, which are mentioned here. And of course, you can seek relief from the district court, and then of course appeal can be there with the high court. So I won't say there are large number of design suits in India, but there are decent number of design suits that we see in several courts in India, be it Delhi High Court, Bombay High Court, Madras, Karnataka High Court. We see a few here and there. Of course, trademark litigations are a lot more, followed by patents, and then comes the design. I won't get into too much of this, but broadly the idea is that the moment you believe you have an article which has a novel design, timely seek for registration for it, and of course see to it that it is adequately protected. So with this, I'll stop sharing my screen, and then maybe since we have 2-3 minutes, we can take a few questions and see.
Yeah. There's a raised hand by Sudhar Kodi. So yeah, Sudhar Kodi, you can unmute.
So I want to ask, like in the case where we are putting both patents and design, should I take care that my patent drawing should not have the appearance of the article there, like the assembled article?
Sorry, I think there was an audio about recording. I couldn't understand your question fully. Okay. Can you come again, please?
So in the case where we are going both for patents and design for article,
yeah.
In the patent drawings also, I'll be showing that article, right? So
yes.
Should I take care that the same, how do I prevent that?
So first thing, the ideal thing is to file those cases simultaneously. Just like I mentioned, even for variants, to try to do it simultaneously. So that's one. Now, even if you're not able to do it exactly on the same day, but maybe a couple of days here and there, but try to, that's one approach you should follow. Okay. Second is that, as I showed you for the design, the kind of images that are required, you saw, are not necessarily similar to what is generally required in the patents. Yeah. So in design, you see, you ask for side view, top view, bottom view, all of that. Often in patents, you will be focusing more on the functionality of the device and not the appearance of the device. Yeah. So while you may have an overlap of 1 or 2 images, which will be same, let's say in design, which may also go into patent, no problem at all. Okay. No problem at all. But just generally, I think they will be quite different in terms of appearance. And having said all this, always make sure that both the cases get filed simultaneously. Yeah. All right. Do we have any other question?
Yeah. So let me just check with my teammates also who are on the call. Anyone from the Venture Center team? Any questions you have? You can just unmute yourself and ask. Meanwhile, the feedback link for this today's session is there in the chat box. Requesting all the attendees to please fill up the feedback form. We can incorporate some of your suggestions in the upcoming sessions which are coming in this talk series. So please feel free to fill up the feedback, and it will be open till today night. So yeah, that was the request. I don't see any raised hand or neither any questions in the chat box. Ravi, thank you so much for today's talk. If there are any more questions beyond this talk series also, then we will reach out to you separately. And anytime you are in Pune, do feel free to visit us.
Absolutely. Absolutely. Thank you so much again to all of you for joining this session. And thank you, Mugdha, one more time for coordinating this. Really appreciate it. Thank you and have a great evening ahead.
Thank you so much. Bye.
Bye.
Bye.